All right, the next matter on our calendar will be Richard Lee versus City of Seattle et al.
Did you get permission? Sure.
Well, I assume, but shall I just step up then?
Now would be the time.
Mr. Lee?
Shall I step up if you don't mind? I'll get water.
Do you have 10 minutes? Do you wish to reserve any portion of that for rebuttal?
2 minutes, please.
Certainly. Proceed.
So may it please the court, Richard Lee, journalist in my 5th decade of practice, age 54, surpassed 40 years at this point. And the matter before us is specifically a Public Records Act case. As you know, it is here because of a successful motion for summary judgment by the oppositional parties, those being City of Seattle, Seattle Police Department, and the widow and daughter, specifically referred to as the Cobains, that is the widow and the daughter of Kurt Cobain, the daughter also the daughter of the widow. At its root, this is not just a Public Records Act case. This is a case that has at its very root the most substantial and essential functions of government, that is to keep people from doing violence to each other, specifically murder in this case, and to prevent the unlawful and unjust acquisition of property in this case being an intellectual property and trademark property known as Nirvana, the value of which could easily be estimated at $1 billion or more. As you've seen in an exhibit I've provided, over 78 million Nirvana records sold to date. And as a third aspect, which is essential to government function, the government must police its own. The government must prevent corruption within the government.
Are you suggesting there's a motivation test in a Public Records Act?
At this point, sir, I'm trying just to establish the real importance of this case. The people of the state of Washington cannot be given the impression or clear evidence that their public officials in the courts, in the elected officials, etc., are willing to tolerate what appears to be someone getting away with murder. That is my point, sir. May I continue?
Yeah, so, but those comments go to your motivation for getting the records, and whether or not the request is appropriate or the disclosure isn't, we normally wouldn't consider those factors.
Well, you might as well just roll that into public interest. The public interest can be defined in various ways. Certainly the public has an interest in making sure that people don't get away with murder and that corruption does not flourish within the government and that large properties are not misappropriated, stolen. If I may continue, in order to succeed with the summary judgment motion, which they did succeed with in the trial court in King County Superior Court, there has to be a finding that there are no material issues of fact to be resolved, which I find an astonishing result, given that that is the criteria at hand. And you may understand that this is all being brought about by 2014 actions by the Seattle Police Department to release 37 photographs from the crime scene and a few other documents. These included pictures of Cobain's body, his hand, his foot, his forearm, his abdomen, a hospital bracelet around the wrist, which is arguably a medical record. And there were then at the same time, by the city's accounting, 55 photographs from the crime scene which were suppressed, not released, not produced in their language. As far as material facts which need to be considered at trial, foremost among all of them is the Szynski report, which was part of the 2014 propaganda effort by the Seattle Police Department, arrived at this conclusion. This is the paragraph above the conclusion by Mr. Szynski, Detective Szynski. Some theorists have suggested that a 20-gauge shotgun would have caused more than the penetrating wounds sustained by victim. This is a completely false assumption. Studies conducted have shown that the wounds sustained by victim were consistent with the load and gauge of the recovered weapon. Penetrating wounds sustained by victim. So why is it that the death certificate that has remained the same since 1994, which was issued the week after the body was discovered, says contact perforating shotgun wound to the head, parentheses, mouth, end parentheses. Why is it in the Szynski report that it's a penetrating only wound, and yet the official death certificate, yet unchanged, calls it a perforating wound? A perforating wound goes in and exits and leaves a bloody mess. So why is it that Detective Szynski has a little meeting with an unnamed person at the King County Medical Examiner and reports, with no sense of irony, with no sense of circumspection to the record, especially the death certificate, that these two terms are completely contradictory, and as I can attest and have at great length, in great detail for the last 24 years, the reason for this is a series of phone calls that I made to the King County Medical Examiner and the Seattle Police Department detectives involved in the Cobain case, wherein, after I discovered video that showed no blood around the head at the scene of the crime, they changed it to a magic bullet scenario. All of the shots stayed inside the skull, and there was no exit wound. These are the police detectives and the King County Medical Examiner's men, including the current King County Medical Examiner, Dr. Richard Hariff, making these claims, but never publicly until the Szynski report of 2014. Dr. Hariff created the outrageous governmental act of publishing a supposedly scientific study in the Journal of Forensic Sciences the next year, September of 1995, wherein he examined the various types of shotgun wounds that can be produced by the various types of shells, including a 3-inch long shell of about 1/2 inch in diameter, which is from the 20-gauge shotgun, the weapon in question. This is an outrageous violation of the published in the same issue, in every issue of the Journal of Forensic Sciences. It says that if an author has a conflict of interest because of a relationship to his current practice, it is unethical, it is a conflict of interest. That person needs to disclose that fact, and obviously if he does not, it's a matter of scientific fraud. And we're down to 34 seconds apparently. Apply the Favish standard to this. Apply the Favish standard that a bald allegation is not enough to release crime scene photos of a body. Well, this is the best retort to the Favish standard, which is that Norm Stamper, in a documentary in 2015, he was chief of police in 1994, and for 6 years thereafter, if I were the chief today, I would reopen this investigation. We should have, in fact, taken steps to study the patterns involved in the behavior of key individuals who had a motive to see Kurt Cobain dead. If Kurt Cobain was, in fact, murdered as opposed to committing suicide, and it was possible to learn that, shame on us for not doing that. That was, in fact, our responsibility. It's a confession that he was chief of police for 6 years and did not do what he was supposed to do. That certainly meets the Favish standard.
Thank you. You'll have 2 minutes on rebuttal.
Thank you.
May it please the court, Michael Ryan, Assistant City Attorney. With me at council table today is Mr. Hunsinger, the attorney for the Cobains. Given our limited amount of time, I will be addressing all of the issues in this case and prepared to answer any questions you might have. In the course of their investigative work, state and local enforcement authorities, by necessity, regularly come into possession of highly sensitive and highly personal information. In this case, that information includes death scene images of a private individual.
As long as you're going to be answering all the questions.
Yes.
So Mr. Hunsinger intervened on behalf of his clients and obtained separate relief from the relief that the city obtained. there's been a skirmish about whether or not that relief is at issue on appeal. I would ask, since time is always fleeting here, I would ask that you would address your position on that skirmish, and by yours, I don't just mean the city, since you are talking for both. And I want you to address whether it covers all things that are sought in the PRA request.
Sure.
Specifically in mind are things like social security numbers and medical records, which do not seem to be part of a due process analysis according to that Ninth Circuit case.
Yes.
Okay?
Absolutely, Your Honor. We do not believe that you need to reach the question of whether or not the death scene images are exempt under the Public Records Act, because that's the ruling that the trial court gave the city of Seattle. In addition to that ruling, the trial court ruled not only were they exempt, but that for the city to release those documents would violate the substantive due process rights of the surviving surviving family members. In other words, it was a 14th Amendment due process right under the Marsh case out of the Ninth Circuit. And if you read Marsh relies heavily upon Favish, which was the Vincent Foster case, which talks about the deeply rooted common law traditions that go back to the time of Antiquity into all civilized civilizations out of respect for the dead. So the judge ruled that we are permanently enjoined from releasing these photos under the substantive due process clause. Mr. Lee did not designate that order in his notice of appeal. Now, he does have a fairly broad notice of appeal. Maybe you can read that. But we do know under cases like Cowwitch County and conservation and all the other cases that if you don't raise an issue in your opening brief, you've waived it. Now, Mr. Lee provided zero argument on the substantive due process issue in his opening brief. And we did have a skirmish about that before the commissioner, and the commissioner said, let the panel decide if that's within the appeal. We think that Mr. Lee has waived that. As a result of his waiver, that is dispositive of the question as to whether the photos are exempt. Because whether or not the photos are exempt under the law enforcement's privacy provisions doesn't make a difference, because at the end of the day, the constitutional rights of the Cobains trump any statutory right that Mr. Lee may have in seeking these photos, or any member of the public. So we believe that that ruling is dispositive of the photos. Now, there are other issues, because there was a second summary judgment motion, because we were a little unclear as to what Mr. Lee's position was. So we wrote him a letter and said, well, what are you claiming we didn't do? We had already moved for summary judgment on the photos, and that's where the Cobains came in. So that first summary judgment order deals with just the death scene images, nothing more. The second round of summary judgment dealt with all of the limited amount of documents that we withheld under different exemptions. For example, the city withheld an autopsy report, which is categorically exempt under the RCWs, and the Reed case talks about that, and the Camarado case talks about that.
There's an autopsy report, there's the argument about social security numbers,
Yes.
There's the whether or not
The drug evaluation,
drug
influence
evaluation.
from the Beverly Hills Police Department.
So you are not contending that the trial court ruling with regard to the substantive due process right applies to that second group of requests?
No, Your Honor, we're not. We're saying, what we're saying with respect to those requests.
I didn't think so, but it wasn't entirely clear.
I apologize.
That's why we have people come here to try and clarify what their arguments are.
Thank you, Your Honor. No, I apologize for that. I think that the substantive due process ruling, to be very clear, only applies to the death scene images, because that's what the Marsh court held, that surviving family members had a substantive due process right out of the dignity for the deceased. And I mean, let's be honest, what's at stake in this case. I mean, there are real human consequences to the release of these documents. I mean, there was a 2-year-old girl at the time who's now 25, 26 years old. This investigation's over 24 years old. And if these images were released, it would cause great harm to the surviving family members. You've seen the declarations from Mr. Kurt Cobain's father, his stepmother, his widow, and most importantly is his daughter. I mean, his daughter has no memories of Mr. Cobain other than the memories she wants to hold. If these images are released, it's a certainty that they will be an internet sensation. They will fly around the internet, and they will be strewn back at this family, just like the images of the poor woman in California who was decapitated in a car accident with Ms. Castoris, and what happened to that family, what happened to the Marshes with respect to their child. There are real human consequences if these documents go
But
out.
Mr. Lee would say, there's still gotta be a way that this evidence can be reviewed by someone to make sure that we don't have merely corrupt process covering up a murder by calling it a suicide.
Well, there are a couple of points there, Your Honor, and the first is, we have provided Mr. Lee with every piece of paper associated with this investigation, except for 52 photos that relate to the body, their death scene images, and they're cataloged on our exemption log. An autopsy report, a 2-page drug influence evaluation from the Beverly Hills Police Department around the time, and a smattering of redactions here or there. So Mr. Lee has a substantial amount of evidence that he can look at to criticize the government's actions in this case. It's not unlike the Favish case at the US Supreme Court dealing with Vincent Foster, because there you had multiple reports and 3,000 pages of documents had been given out, and there was nothing specific about the photos. And if all one can do is come in and say, well, I don't agree with the investigation, and therefore these deeply held privacy rights. Now, assuming the court even needs to reach
Is it
this
in any
issue.
way significant to the evaluation? And if so, in what way is it significant? That at the time of his death, Mr. Foster was a person who was employed in a position of public trust, whereas at the time of his death, Mr. Cobain was a self-employed resident of the county.
I think it absolutely is a difference. I mean, in Vincent Foster's case, there's even more. You know, what the FOIA drives at and what the PRA drives at is the right to know what your government is up to. And Vincent Foster was in the middle of something, you know, some investigation that was going on related to President Clinton, the highest levels of government. I mean, think about it. We have cases where the autopsy photos.
What if the question here is, did the prosecuting attorney for the county improperly refuse to prosecute or direct further investigation of a murder suspect?
Well,
Should we excuse looking at the prosecutor for that because there was a celebrity and sensationalism involved, or should we be just as concerned regardless of the notoriety of the person?
Well, I think the Favish court deals with that, because what they say is, look, we understand that there may be an instance some point somewhere, right? And what they say in Favish, it's not that you just get into the door when you make some credible allegations, and then there needs to be some form of balancing between the privacy interests and what the allegations are. You just get into the door. In Favish, he made similar arguments, that there was an exit wound in the neck and not the back of the head, and all of these. It's the same arguments we're seeing here. That was insufficient to even get into the point under the FOIA where there is a balance. So we're not disclosing the possibility that someday, somewhere, there may be sufficient enough conduct. But I mean, I think it's interesting because what they kind of said in the Favish case was, if you've gotten to that point where you've made a compelling enough case to show that the prosecution did something wrong, and you got that through the FOIA or the PRA, well, then the FOIA or the PRA has already done its work. That the photos you don't need to see those to at the end of the day to make that determination, because the FOIA has already done its job. Again, we've given Mr. Lee the entirety of this file, save for 52 photos that show the body of Kurt Cobain on the day or several days after he committed suicide when he was found. Those are deeply personal photographs that the family members should not have to have disclosed to the public eye. Unless there are any further questions, I'm happy to answer them. Thank you.
Well, as I've expressed thoroughly in writing in the briefs, I did not intend to overlook the claims about substantial due process. Obviously, the Cobains, so-called, are given an extraordinary level of due process in the fact that this is a public records request, and they have the expert assistance of the city of Seattle in covering up facts that they do not want public. As Mr. Ryan has conceded, obviously expressed in emotional terms, these images, once released, will be news immediately all over the world in every language, I think it's fair to say. And that is because of public interest. And where does the public interest come from? Not only myself, but the Seattle Police Department and the King County Medical Examiner enthusiastically participating in the Unsolved Mysteries program on NBC in 1997. 14 minutes of discussing this case, their side of this case. Courtney Love Cobain, 2 days after the body was discovered, there was a huge show business event at the Seattle Center in which she repeatedly referred to the decedent as an asshole and a fucker. Now, in any other homicide case, when the spouse comes out with statements like that, people would be saying, gee, that makes her look suspicious. Perhaps this person should be considered a person of interest in this homicide. The daughter herself, age 25, I believe now, born in 1992, has recently expressed her interest and fascination with the Church of Satan, the infamous Church of Satan affiliated with the Manson clan. These people are not the victims of scandalmonger Richard Lee. These people are the scandalmongers. They are in the scandal-mongering business. They released a documentary calling Kurt Cobain a rapist with no evidence whatsoever, which has been refuted by his friends.
Thank you, Mr. Lee. Thank you all. That concludes our calendar for today. Court will be in recess.